We're going to start having people arrested, and they're going to be brought before the court. Then forthwith, a complaint will be filed, and we will start having bond hearings every single time a person is arrested. This is outrageous. This is a 1 o'clock, but it is a GF. And this man and his wife just walked 2 hours to be here this morning. And I don't believe that we have anything filed, do we?
No.
We will go on the record in the matter 26 GF 133, group file of Brandon Campo. Appearances are we do have appearing in person, the district attorney, Kevin Schmidt. Mr. Campo appears in person without counsel. We are in victims' rights compliance because the victim is sitting right back there, Ms. Bauer. That is the victim. Look at her face. That is who she is. And so we have Mr. Campo here. This matter, he was brought before the court for the court to put him on a cash bond, a significant cash bond on May 26, 2026. There is enough there for the court to make a probable cause finding because the court does have at least a small police report in this matter. And so he is here, was scheduled at 1 o'clock, but the man and his wife have walked 2 hours to get here. Correct, Mr. Campo?
That's correct.
You don't have a means of transportation?
No.
And so why are you here at 1 o'clock? Or why are you here now instead of 1 o'clock?
I was trying to get the court date changed because I don't have an attorney.
Because you don't have an attorney, but I understand that, but you don't even have charges filed against you. You understand that part?
So I didn't have to appear?
I would say probably no, because there's nothing filed, but you do have cash, $1,000 cash that was posted based upon a very lengthy probable cause statement with facts enough that you could have been charged or probably should have been charged by now, since it is June 24th, almost a month past the date. You are dressed very nice for court. Thank you for wearing a shirt and a tie. You look fantastic.
Thank you.
Why don't we have anything charged? Almost 1 month to the day or two later.
Because one of the charges lacks probable cause in the police reports.
Then don't charge that charge, but he should be charged by now.
No, because I've asked for police follow-up to find the probable cause for that count.
I thought you started
Multiple
something in Polk County where the day that they're arrested, they get probable cause, they get their initial appearance, they have a complaint filed. This should happen here too, because it's almost 1 month since this man was arrested, put on bail with significant cash of $1,000 with bail condition. If there's one count that is not yet enough for probable cause, then you can ask to amend the court. You know the statute, you know the rules. But now we have a man here he's been under a bail bond condition for almost 1 month with $1,000 cash, and we don't know if there's enough to charge. There's enough at least for probable cause for some of these. You can amend later. You can even amend an information upon preliminary hearing. Right now, this is ridiculous that it's almost 1 month since his arrest, since he was put on cash bail, that he has not been charged.
Judge, we wait for complete reports before filing complaints because our policy is that cases are provable and triable the day we charge them. It's not right now. That is my office's policy.
You can't though. You can't prove and charge any of these, so you don't want to file anything because again, discussions of the fact that when you worked at Polk, you developed this system and it's to have all of these things. I don't know if you did that or who did this, but when a man's arrested or a woman's arrested in a lot of counties in the state and per the statute, they are to be immediately provided their criminal complaint. Is it directory? Is it mandatory? Who knows? But in a lot of counties, it happens the day of arrest. And there are amendments to the criminal complaint or amendments to the information. But now it is June 24th. And again, this man was arrested on May 22nd. He was arrested. May 22nd, he was arrested. But the court did place bond and cash on him on May 26th.
Correct. If the court conducted a bond hearing within 72 hours of arrest, I could have told the court of this, but our county doesn't do that.
Our county should do that. Our county should do that. Because I guess I'll pull up the statute right now. Because people's rights are restricted. That's why most, or a lot of counties, I can't say most, because we're one of the little counties that apparently don't want to do that. I'm sure you know the statute and you can probably pull it up a lot faster than I can, since that is your job every day. The state must file a complaint without unnecessary delay following arrest, which generally can be interpreted as 48 hours. 48 hours. And that's not just for the court to determine bail, but it should be filed. It should be filed with unnecessary delay. And to this court, this has been beyond an unnecessary delay. When a person is arrested without a warrant and brought before a court, before a judge, a complaint shall be filed forthwith. Forthwith.
This person was never brought before a judge. Bond was set in his absence.
The probable cause was brought before the court with enough information for the court to determine probable cause. So if we're going to start having people arrested and they're going to be brought before the court, then forthwith a complaint will be filed and we will start having bond hearings every single time a person is arrested. This is outrageous. It is completely outrageous.
I would approve of that process. That's why Captain Taggart asked the court to.
Oh, good. Then we're going to start doing that now. And so we will have a complaint filed forthwith at the bail hearing, correct?
We will not.
Then we will not arrest people. Then they will be not arrested and we will not see them, because bail should not be placed on a person unless a person is arrested without a warrant and brought before a judge, which they will be. A complaint shall be filed forthwith. And if other counties, including Polk County, can file it and get it done the day of the arrest, within hours of an arrest, I think Burnett County can do that too.
We will file it forthwith after those bond hearings if the court starts bond hearings.
All right, then I'll do that. And we'll have the bond hearing. And then the very next day, we'll have the initial appearance. That was forthwith for the court. So is that what we're going to do, Mr. Schmidt?
I'd have to confer with law enforcement because they have not been consulted with this yet and not been given an opportunity to prepare.
There's enough. Do you understand what the PC comments or complaints that are filed, the probable cause complaints? They have a lot of information. They are puked with a whole lot of information. The officers do such a fantastic job for the most part in those probable cause statements. Enough where a complaint can be filed. Enough. I can even read this complaint that was filed by the Siren Police Department. There is enough there, right there, enough there that a complaint can be filed. That is forthwith. And all you do is cut and paste and put their complaint into the complaint, or their police reports into the complaints anyway.
Judge, the probable cause statement, you may have noticed, does not state when the drinking occurred in regards to when the crash happened. Does not state when the moment of driving was. It does not state whether an officer was actually spat on or not. And it does not say whether anyone was injured in the crash.
Well, then that is a Siren Police Department issue that you can talk with Siren Police Department. But I'm going to tell you, our county boys and girls and women and everybody, all of our county people, our county officers and deputies, they put a lot into their probable cause. A lot.
They do.
And so then I guess with Siren Police Department people, if that's what you're saying is the issue here, then perhaps they need to be trained on how to put in all of the information in a probable cause so we can forthwith have charges.
And again, I don't charge based on probable cause. I charge based upon beyond a reasonable doubt.
Then we cannot have bail. Then we cannot have bail or bond conditions. So people need to be let out immediately, forthwith.
We can have bail conditions set based upon probable cause statements, and the complaints can be filed forthwith. We have the capacity to do that so long as law enforcement knows and they can prepare for it.
All right. Forthwith, within 48 hours, I will do bail. Within 48 hours, we will have the initial appearances in every single arrest, every single that comes in front of this court for bail and bond.
I will speak with law enforcement of what the court's command is. I am going to be gone for the next 2 weeks, so there will be that problem.
Because to me, forthwith does not mean 1 month and 2 days after an arrest. That is not forthwith.
It does not. If there was a bond hearing, I would have told the court to do a signature bond for these reasons.
I would not do any bond, zero bond, none bond, because unless it's forthwith within 48 hours, nobody should have their due process rights taken away because we can't get a criminal complaint filed forthwith.
I agree. It is unreasonable for people to be on a cash bond without seeing a court and no.
Any bail bond conditions, because right now, this individual, if I have him on bail bond conditions, this individual, and he's not getting a complaint filed a month and 2 days after, why should he risk to have bail bond jump violations when he hasn't even been charged? He doesn't even know if he is going to be charged.
I agree.
So zero bail, zero bond, unless we have a criminal complaint filed forthwith within 48 hours.
I agree.
Done. Then that's what we're going to do. So, Mr. Campo, I'm not sure if you are supposed to have a complaint filed today. I'm hearing no.
Okay.
So you are forthwith discharged from all bail bond conditions. Forthwith. Now,
Really?
immediately. Cash will be returned to you. And bond, gonzo.
Amazing.
Okay? Thank you.
Thank you.
Mr. Linder.